Well, thank you, Lisa and Greg, both for having me today. I appreciate it. Thank you for coming and listening. Like both Greg and Lisa said, I'm going to give you kind of how all of this gets interpreted in the field and what is still nebulous as opposed to clear. I think you'll leave here with one theme, and that is that there's probably still more we don't know than we do know at the moment. Just a little bit about wetland studies for a moment. We do a lot more than wetlands work. We started in the wetland stream delineation and regulatory restoration program. We've gone into a lot of other services to kind of deal with environmental due diligence, as well as land use environmental matters. And this is kind of a simple bar chart of everything that happened last year that Greg and Lisa talked about. And if you think, gee, that seems like a fair amount of regulatory issues coming to the citizenry of the United States in a year, you're right. This was an extremely complex regulatory year. I think Lisa and Greg have covered it pretty well, so I'm going to kind of skip that and get to what the world looks like after both Sackett and the rulemaking. If you see Virginia there, Virginia's purple, and this is not a political map. This is a map of whether a state is within the regulatory framework of the Waters of the U.S. rule that was published in January and then updated in May, and I think became effective in September. Virginia and all the purple states are not under the formal regulation. The green states are. Why is that? Well, if you go back 1 second, you'll see that in March and April of last year, there were 2 district courts that heard cases about the January Waters of the U.S. rule. The judge threw out application of that to the states that joined those cases, which are the ones that are in the purple. And as a consequence, we're not technically under the Water of the U.S. rule. We're under what they call a pre-2015 regulatory regime. And I'll just say that it's basically the same thing as the Waters rule. Why that's important, though, is you have the federal government at the moment as a regulation that applies only to about half of the states in the United States. And that's relevant for some conclusions later, which are kind of jumping to the end, that there are many that wonder if both the Corps and EPA are working towards a new Water of the U.S. rule to republish that, get public comment, finalize it so that they have something that covers the whole fabric of the country as opposed to just half. So the first thing I want to talk about is what Sackett did not change. Traditional navigable waters, you may have heard that today a couple times. You know, the territorial seas, the Atlantic Ocean, the Caribbean for areas that we regulate, navigable waters like the James River, interstate waters, Roanoke River, those types of things, they've always been regulated. They'll be continue to regulate it, as Lisa was saying, because of the Commerce Clause of the Constitution. They involve interstate commerce. Even a river inside Virginia that's not interstate, if you could float a canoe in it, you have interstate commerce. So those are regulated. The other thing is any impoundments of those waters are regulated. And then the definition of wetlands has not changed. The 3 criteria you've heard about for years and years, those are still set in stone. And then lastly, as Lisa was saying, the Commonwealth of Virginia's regulatory program is unchanged. Virginia regulates all wetlands, both regulated by the federal government and those not regulated by the federal government. So then what did Sackett reconfirm? Sackett came somewhat on the heels of the Rapanos court decision. And in Rapanos, they came up with a term called relatively permanent water. And what the courts, and then Sackett unanimously reconfirmed that test. And a relatively permanent water are those that flow all year long, known as a perennial stream or perennial water, and those that have seasonal flows, what the court said. Seasonal being what we typically classify as intermittent waters. Basically, if you've got water in something for 3 months in the middle of the winter in this area, you've probably got a relatively permanent water. So that is what the court reconfirmed for clarity. And then we have this other type of water, basically a ditch or a natural area, I call them conveyances, that will transport water immediately after a rain event. So you probably have seen ditches along roadsides or farm ditches that will flow the day of a rainstorm, the day after, maybe 2 days, 3 days, and then are dry. Those are what we call ephemeral waters. Those are no longer regulated by the federal government. And that was the case under Rapanos, and it was reconfirmed by Sackett. So that's nice that we have some kind of continuity between court decisions. The big thing is what has changed is these wetlands that are regulated by the federal government, and those are kind of lumped into one category called adjacent wetlands. As Lisa was saying, they got rid of the significant nexus test from Rapanos and said that's too vague and broad. They created this two-step test and used the term indistinguishable. So the two-step test is that first of all, you've got to have a relatively permanent water connected to a traditional navigable water. That's the thing that establishes interstate boundaries. Okay. So you got to have that relatively permanent water connected to a traditional water. And then the wetland has to have a continuous surface connection with the water. This is a quote, making it difficult to determine where the water ends and the wetland begins. That is both Greg and Lisa were saying. When we consultants who are not attorneys read the Supreme Court decision, we said, gee whiz, this is pretty clear, concise, strongly worded, non-nebulous. This is about as clearly written as it can be. And then in the summary of the case, the conclusion section, they said, in sum, we hold that the Clean Water Act extends to only those wetlands with a continuous surface water connection to bodies that are waters of the United States in their own right, so that they are indistinguishable from those waters. So to us, that's the most important paragraph, because that really connects all the dots for us in the field, or at least so we thought. What we are experiencing is similar to what other states are experiencing. Our company, Wetland Studies, is part of the Davey Tree Expert Company. We're a national firm with 10,000 folks in it. We have offices that are regulated by both the Virginia, North Carolina, and Tennessee districts of the Corps. What we've been able to see is a variety of situations that are in the field that are different than what the wording in the Supreme Court case is. And I would say most of these also have not yet been resolved. They're being pushed up the chain at various offices in the Corps, and I'll talk about that process in a minute. The first thing I'm going to mention is just that there's a backlog in the amount of JDs the Corps is trying to confirm right now. As of October, there were about 500 of them in backlog. The Corps is taking anywhere from 6 to 9 to 12 months to confirm a wetland decision. What they're doing is trying to push people to what's called preliminary jurisdictional delineation, saying that those are faster. The problem is if you accept one of those, you've conceded that all the wetlands on your property are regulated by the federal government. And that has implications on the permitting. So that's not the best way to go. In some cases it is, but in most cases it is not. What are we seeing in the field? We're seeing them regulating ephemeral waters immediately upstream of these relatively permanent waters. So if you have a little headwater channel above a perennial stream, they'll often try to regulate those. They're saying that any wetland next to those ephemeral features are regulated. They're saying that wetlands adjacent to a topographic crenulation is adjacent, and that's a new one. I don't even know what a topographic crenulation is. It's basically if you look at a topo sheet and you see a little V in your elevation and a wetland downstream of that, meaning water kind of flows that way. Some districts are claiming that's enough to say that the wetland next to that is adjacent. And then we've got a case where there's farm pond excavated and dry land is what the regulatory term is, but normal parlance, just a pond and upland, and connected downstream by an ephemeral conveyance that was dug to discharge the water from that pond, connects to a tributary. And in that case, the Corps is saying that it's jurisdictional. Now, in those cases where we have a disagreement with them and the owner agrees that we should take it to the next level, that can go then to the district and EPA headquarters, and be reviewed. And several of those are happening all over the country. Unfortunately, none of us know which ones they are unless somebody is nice enough to share those findings with us. And then the big issue is post-Sackett, we have no written guidance from the Corps at all about how to interpret Sackett in the field. None. So the picture is worth 1,000 words, and WSSI has had this kind of schematic now for, I think, going on about 10 years. We call it Wetlandia, the country of Wetlandia. And the country has undergone a lot of changes in several years. So you're going to see I'm just going to walk you through kind of the basis of this thing, just so you kind of get the premise for it. At the bottom, you see a line that runs left to right. There's gray below it, that's state Y. Everything above it is state X, the state that we're in, that's yellow. So then you see this dark blue double line running through that. That's our perennial water body, and it's interstate. So by definition, if Wetlandia was part of the United States, you'd have regulation of that water. Then you see a tributary break off of that kind of near the lower left, and that is also blue. So that's perennial. That's a relatively permanent water, which the Corps would regulate. And then you see blue lines with dots, and those are our intermittent streams, kind of the seasonal streams that by definition under Rapanos and Sackett that the federal government regulates. Now, in the days of Rapanos, everything on this slide would be regulated, in my humble opinion. And the reason is they had enormous discretion. And you'll see that dashed circle in the middle. That is the land of significant nexus. And significant nexus was a term out of the Rapanos case that gave the Corps a lot of flexibility in how they could interpret whether a wetland had significant nexus to a downstream water. More often than not, they found that it did, and they could regulate it. So this is what was regulated prior to Sackett. Okay. The next slide is what we consultants would think or have thought falls out of jurisdiction post-Sackett. So, and again, at the federal level, state of Virginia still regulates everything, but the federal government, as we would read it, would not regulate most of the wetlands on that presentation. And several of the dotted lines, the ditches, small black dash lines, ditches again, and are typically excluded if they're not through a wetland. And you'll see that none of them are in this particular example. Ephemeral conveyances, not jurisdictional. Wetlands up the slope of a ditch or a conveyance, not jurisdictional. Upslope of a ditch or a ephemeral conveyance, not jurisdictional. And then you see in that land of significant nexus that all the wetlands in that case are not jurisdictional per Sackett as it's read in black and white. Because, frankly, because Sackett has no vagaries in it. It's one of the few Supreme Court decisions you can read from beginning to end, and there's nothing inconsistent in the ruling. This is really kind of where we are. Okay, the X's are still there. Those are the ones we think are jurisdictional. The question marks are all the things that we're not sure about as a consequence of having conversations with the Corps in the field, either in Virginia, North Carolina, or Tennessee districts. I will also point you to a couple things, and it's hard to see, but in red, I'll start on the left side. In the corner, you're going to see kind of a red parenthetical, and it says correct as of 2/16. I think it's 2/16.
Yep.
Yeah. So February 16th of 2024, there was a case in St. Louis where there is one conveyance. And as you can see, it's one tributary. There's nothing leading into it from either side. Most of it is ephemeral, and there's a piece that's intermittent. And in St. Louis, the piece that was intermittent is a piece that was on a person's property, and they wanted a jurisdictional determination. The Corps thought it was jurisdictional. The people protested and said, well, most of that reach is ephemeral. It just happens to be there's a piece that seems to have water sitting in it. Maybe it's flowing, and I don't know all the details of it. I've read the memo. But the applicant said, we don't think that's jurisdiction. So they pushed that up to headquarters, and headquarters agreed. Said if most of the reach is ephemeral, it doesn't matter that there's a piece of it in between that's not. So that's kind of a nice ruling to have in writing. The problem is I wouldn't know about that unless the National Association of Home Builders was nice enough to give it to me when I asked if they'd gotten any guidance, because that's kind of what we're doing now in our delineation world, is literally coordinating with industry groups to find out if any information is available. Because again, once this decision was made in St. Louis, it is not made public. It's not what it's distributed on a web page by the Corps. There's another one in the far upper right corner, and that is if you'll notice, there's a road that crosses through, may have crossed through, and in fact, the way I drew it, I'm pretending it did cross through a wetland at some point. Let's assume the road was built legally, okay, before the Clean Water Act. There's no ditches on either side of the road, and on the upslope side, kind of on the right side, looking at it, that wetland touches that perennial water. So that's an adjacent one. The question is, well, what's that wetland on the other side? It doesn't touch the perennial water, so it's not functionally adjacent. The road was built legally and there's no ditch connecting the two. And in this case, this came up in Buffalo. And the Buffalo district sent it up to headquarters and EPA, both headquarters and Corps and EPA, and said, what do you want us to do with this? And in that case, they quote unquote kind of remanded it back to that district and said, well, you need to go out there and see if the vegetation between these two wetlands are similar, and whether you can find any indication that via groundwater that they're interconnected. And if you can, then that wetland on the south side of that road is part of the adjacent wetland. And that to me is a pretty strange opinion, but that's the opinion that's been given in writing, again, specific to that particular project. And that kind of illustrates the problem that we're having, is we're finding this stuff out piecemeal. And I can go into more examples, but that kind of paints the picture. And you'll see most of the examples up there still have questions marks next to them with no dates, which means we don't have any policy on. So this is kind of the status of the program. There are 2 Freedom of Information Act requests out to the Corps and EPA. The state of Virginia has filed a Freedom of Information Act request and wants all documents related to the Corps' internal decision making. And frankly, the Corps has distributed written policy to the districts for how to interpret field conditions. I think they're being kind of validated and information fed back to headquarters, and they're drafting updates, but they've not released any of that to the public. So we have no sense of kind of where they started, where they're going, how it's changed, how it would affect our clients' properties. The National Association of Home Builders also issued their FOIA to the Corps and headquarters, Corps and EPA headquarters back in October of last year. It's been about 9 months since the decision. It's a good 120 days since the FOIAs went in. There's over 1,000 pages of documents that are being held at the EPA and Department of Justice. We know that because the Corps has notified NAHB, and they cannot release any of that material until those 2 agencies go through them and redact anything that they want to before it's released to the public. So that's where we are in field guidance. With regard to the regulation, what's going on, the EPA just had a listening session. And I have to say it was one of the most confusing listening sessions I ever participated in, because they didn't tell me who was listening. Where they were listening to us, we got to speak. I wondered if we were going to listen to them and have them tell us kind of where they were in the regulatory world. And they really didn't say. And the big question that's not being answered is, are you writing a new regulation or are you not writing a new regulation? And when is field guidance coming? In my humble opinion, you could issue guidance under Sackett and then redo the water of the US rule. And once the rule gets finalized, tell everybody to apply the guidance, because I don't think that field guidance would change. And even if it did, you could change it later. But we don't have either of these things right now, and there's a lot of confusion. So they got their earful from the industry group on the 28th, and I'm sure they got the same kind of message from all these different groups: agriculture, the environmental NGOs and tribes and states, because there's just no guidance out there to help clarify how to interpret this Supreme Court decision that seems so clear in the field. And that is kind of what's still missing. You know, it's like I said, the first anniversary of Sackett's coming up in May. For the Rapanos case, it took about a year to get guidance, so I would hope that we're close to getting it. And then these two memos came out that I illustrated just a month ago, and that's all we got for right now. So if you feel like things are a little confusing and hazy on a project of yours, it's probably because it is. Until we get the Corps out in the field to confirm things, we just can't make predictions on how things are happening on other projects. And with that, you know, the conclusion is just kind of stay tuned on the federal side. Virginia is still regulating all wetlands. Virginia has established what's called an SSWD process, State Surface Water Determination process, where you can submit a jurisdictional determination to the state, and they'll review it and confirm it. If you have certified delineators, state certified delineators, they'll typically confirm it 30 days, 45 days on the outside. That's a great process, but they only confirm what's jurisdictional to the state. They cannot comment on whether the Corps will accept the boundaries of the wetland, or whether they might change, or what's jurisdictional to the Corps. So in common lexicon, you get a half a loaf, but it's better than none. The Corps is still taking 9 to 12 months to confirm most wetlands. And then we do know some things with the federal regulatory program, but we're still kind of waiting on the ones that have big influence on their jurisdiction. With that, I think we're at questions.